Hey, what's up? What's up? It's your girl Neek, and you're tuned in to Neek at Night. And today has been a very, very eventful day at the Diddy trial. Now, today was deliberation day 2, and the jury came back with a verdict on counts 2 through 5. Now, they did not come back with a verdict for count 1, which is the racketeering. And it had the courtroom in shambles, the internet in shambles. Diddy's team looked shook. It was a lot going on. And I'm going to give you guys the transcripts to go over all of the things that was said in court today. Now, I don't know if I'm going to read every little detail, but I'm going to read to you guys a lot of what went on today. And also, I pulled up the transcripts of the guy who the jurors wanted to hear from. Now, if you guys don't know, one of the major notes that the jury requested a transcript from was the first witness that the government called, or day 1 of trial. I think he was the second witness that the government called. All right. So right after opening statements, right after they started moving and grooving and swinging and saying what they felt like Diddy was going to be charged with, they called a guy by the name of Daniel Phillips, who testified about an encounter where he had to engage in a freak off with Cassie. Now, the jury wanted to know the specific details from his testimony because it was alleged that he witnessed or he overheard Diddy giving Cassie the beats and then her not wanting to engage in a freak off, and then him trying to do the freak off, but his Johnson didn't rise to the occasion. Okay. And that was one of the things that the prosecutors focused on in their closing arguments, where they stated that even though the act was not completed, she was forced into that situation, and had his Johnson rose up, then it would have, been a slam dunk force thing. But they said it didn't even have to go all the way for it to fall under the force, fraud, and coercion as it pertains to Cassie. So without further ado, we're going to get on into these transcripts. Now, I'm going to give you guys a disclaimer. I don't talk real fast or whatever. And the lovely thing about this is when there are long lives or when I'm reading through transcripts, and if you guys want to speed up my voice or speed up how I talk, you guys can go into the settings after I'm done being live. You can go in the settings of your YouTube and you can speed me up or slow me down, however you want to do it. And that way it's an enjoyable, listening experience for everybody. If you guys have not hit the like button, make sure you hit the like button as well. And if y'all have not checked out CNN, I mean, if you can't go to Bella Noche's, where can you go? If y'all have not checked out my little appearance on CNN, I mean, what are we doing? Okay, what are we doing? All right, so I was on CNN.com as one of the featured influencers that was covering the Diddy trial, and I was elated that they even put me on their thumbnail, that they had to advertise the article, and I was on the main page of the Diddy updates as today being the verdict reaching, and me on the same page as all of that information or whatever. Like, I'm in the feed of all of the chaos that went on today. My face is scrolled in between all of it. I mean, crazy. How many people be watching CNN? I don't know, but I feel like, hey, that is something. You know what I'm saying? That's something. But let me actually pull. Do y'all want to see that first, or nah? Y'all want to hear the Diddy stuff? I'll do a separate live and do that. Y'all came for the Diddy stuff, so let's get into it. All right. So Oh, somebody said, so happy you stayed. Thank you so much for the super chat. I am actually happy that I stayed as well. I was contemplating on leaving, and I was, I was like, child, I am over it. But I'm definitely glad I stayed. Now, tomorrow, I told myself, I said, child, we are not going to be, we're not wearing any shoes that's not comfortable. I need to have sneakers on and have them laced tight, because I just anticipate it to be a whole lot of tomorrow, and I need to be able to move around. Okay, the shoes that I had on today was little church shoes that, you know what I mean, you can't really move like you need to move when you need to move. So that's what's gonna happen tomorrow. I'm gonna have my sneakers on Trump tight, period. Okay, comfortable wear, pants. We ain't playing no games. but all right, so let's get on into these transcripts. So as you guys know, the jury came back with a verdict on counts 2 through 5. Now, these counts, and let me pull up a diagram so that you can see exactly what the counts are. And it's also important to note, or I find rather interesting, that they never asked one single question about Jane. All right. From my recollection, the only time that the juror has been asking questions has been pertaining to Cassie Ventura. All right. And what did I tell you guys? Out of anything that I've seen in this trial, I feel like when it comes to Cassie, it's a wrap. Now, as it pertains to Jane, I have maintained that that's a slippery slope. I really don't know what that's going to give as it pertains to Jane. But if you guys realize, anytime a note came in, it's Cassie, 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 Cassie. And what did I tell y'all? Cassie was the one that I felt like it was clear. Okay. It was clear, and the picture don't get no clearer than that one. All right. So what's up? What's up? What's up? The Real Rap Show. He is so cool, y'all. Y'all definitely follow him. So let me pull up this. Let me pull up a few things that I should have already had queued up, but child, it's been a lot going on. It's been a lot going on. It's been a lot going on. Let me pull up this verdict thing that shows what's being charged and what counts a verdict was reached already. All right. So this will give you guys a clear picture and indication of what he has. Wait, hold on. Where? Come on now. Airdrop. It say airdrop complete. Why I don't see it? Show and folder. Where they at? Where they at? Where they at? Hold on. Why my airdrops ain't showing? I don't appreciate that. What's happening here? What's happening? Come on. Slowing up the progress. Can I drop this like that? Oh, boom. All right, boom. Here we go. Sorry, y'all. It's late. Bear with me. All right. So this is what's at stake right now. So as it pertains to count 1, they have not reached a verdict on count 1 yet. As it pertains to count 2, which is S trafficking by force, fraud, or coercion, as it pertains to Cassie Ventura, they have reached a verdict. As it pertains to count 3, transportation to engage in prostitution, as it pertains to Cassie Ventura, they have reached a verdict. Count 4, S trafficking by force, fraud, or coercion with Jane, verdict. Count 5, transportation to engage in prostitution with Jane, verdict. So they have a verdict for all of the counts that pertain to Cassie and Jane, and they do not have a count that is for the racketeering. And in my humble opinion, it's very possible that it is guilty for Cassie, and maybe not guilty for the force fraud or coercion for Jane, but then it could either be guilty or not guilty for the transportation of the prostitutes, because that was clear. Now the counts, let me pull the counts back up. Count count 4, I feel like is the possibility that it could be not guilty. Count 5, it is a possibility that's not guilty, and a possibility that it can be guilty because they did prove that he was taking them across state lines. So I'm very interested to see. Now, another thing that people need to consider is, outside of the evidence that we saw in the trial, there was also evidence that the jury saw that we didn't. So the jury was able to see the freak offs. Okay. We don't know how egregious or relaxed those videos were. The jury, it was one day that I was sitting in the courtroom. Okay. And I was in the overflow room. So we just sit there and watch the screen of what's going on in the main courtroom. And it was one day that they were playing freak offs. And I could have sworn we were sitting there for like an hour. Okay. One video was like 39 minutes. The prosecution had played like 2 or 3 minutes of that particular video. And then when the defense got up, they played like 20 minutes of this video, 10 minutes of that video. And so all we get to do is sit there and watch the screen of all of the attorneys having headphones on. We don't get to hear any of the freak off. We don't get to see any of the freak off. We just get to sit and watch the person that's on the witness stand and the prosecutor. So the person, it was 2 different agents. It was a female and then it was a male who was introducing that evidence in. And the male, you see him with his headphones while he's watching the freak off, and he's just looking, trying to keep a straight face. Same with the female agent. So you couldn't really gauge what they saw, if it was heinous or what, but they just, kept a poker face as we watched, and we just sat there in silence because we can't hear nothing. They can. So they saw a lot of things that we did not see. Okay. So they have way more information than we have. And with the information that I do have, I feel like it's clear as day for Cassie, but that does not mean the jury can't surprise us. All right. The jury can go a whole nother way and, vote a whole nother way in its entirety. All right. So with that being said, let's pull up some of the transcripts from today and bring you guys into some of the courtroom, because it's interesting. Oh, wait. I almost forgot. We got Gina making an appearance. Now, if y'all don't know who Gina is the girl who did an interview with Tasha K way before the Cassie lawsuit. All right. She was supposed to be victim number 3 in this case. Now, Gina, she basically stated that he made her lose a baby. He stumped her out. She talked about all of these acts that he did to her, where he beat her on several different occasions. And one time she talked about how she was with child and he beat her and it caused her to miscarry. Now, she said all of these things on Tasha K's interview, but surprisingly, once the jury goes into deliberation, oh, wow, we find the missing victim. Gina just somehow reappears. And guess what Gina is saying? Gina is saying that he ain't never did nothing to me. I'm not scared because he never did anything dangerous to me. And I'm like, it's mighty convenient, Miss Mamas, that when they go into deliberation, you suddenly magically appear when you've been missing this whole time. And that government has been trying to get you on the stand. And they had you listed as a victim, meaning that they talked to you already. You gave them a story and then you backed out. Now, I don't know if she feel like the reward on the other side is going to be a little bit more worth it, but she definitely talked to the government for them to list her in their case. And then suddenly you pop out. Girl, I don't know if that's giving a charge or if they could charge you with whatever. I don't know, but girl, child, it needs to be repercussions for Gina for wasting the government's time. But let me pull this up. Here this heifer go right here. Let's look at Gina, y'all.
Hi, Gina. How you doing? I have a quick question for you. Do you think Diddy's gonna win this trial? You don't know? Okay. I've been hearing a lot of stories. Everybody been hearing like maybe you were kidnapped or like something like crazy. Like we're just hearing a lot of stuff. Is there anything you can clear up or anything like that?
No, I'm safe. I'm not kidnapped.
Real quick, before you go, that's what I want to know. If Diddy does win this trial, do you think your life will be threatened in any kind of way?
No.
You don't think so? You think everything will be safe? Because the girl Aubrey O'Day, she said that if Diddy wins, she's gonna leave the country.
I mean, he never did anything dangerous to me. I'm not scared.
You're not scared? Okay, well, I appreciate that. Thank you. That's all I wanted to know. Okay. Hi, Gina. How you doing? If he is,
and mind you, the Aubrey interview just happened, so it's given something might have been slid. If you get my drift, it's given I'm waiting for the benefits from the other side. Okay. But anyways, let's continue to get into the goings on that's going on, because baby, it was an eventful day. Okay. It was an eventful day, y'all. So let me pull up the transcripts. Pull up my watermark. Let's pull up the transcripts. All right. Oh, wait. Boom. Take that off. Wait. All right. All right. Y'all ready? Y'all ready? Y'all ready? All right. Where should we start? Or should we start with Daniel Phillips' testimony? Which one do y'all want to start with? Do y'all want to start with me reading through the transcripts from today, or me going to the transcripts that the jurors requested? Which one do y'all think that I should start with first? Because, child, we gonna get to it. Y'all want Daniel's testimony or the court transcripts from today? All right. Y'all say the ones from today. All right. So, and just to let you guys know, I don't have the actual jury room transcripts. I just have what was talked about in open court when the notes came in, just to be clear. All right. There is nobody who knows what is being said inside the actual deliberation room. What I'm showing you guys today is the transcripts when there was a note that came in, when the attorneys responded, when the verdict was reached, what they said, what that's these transcripts. All right. So just to be clear, I don't know if y'all thought that I was finna read to y'all what the jurors was talking about. No, these are the transcripts from the court on what the court was saying. Y'all get my drift? All right, cool. Because, it'd be some slow people like, I thought I was going to hear the jury deliberations. Like, no, not the actual deliberations. Nobody hears that. All right, now we got that understood. Let's get to it. All right, so the judge says, in response to the jury's note from 4:30 p.m. yesterday, the court will proceed with its original approach to refer the jury to page 37, lines 1 through 3, which answers the question directly asked by the jury. It says, United States v. Cummings, blah, 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 holding that the district court did not, much less abuse his discretion in responding to the jury by rereading the relevant portions of the jury instructions. The defense proposal to simply refer to the entirety of the instructions on the rug distribution offense is non-responsive to the very direct and precise questions asked by the jury. It would also introduce confusion and potentially mislead the jury by suggesting without any guidance that the answer lies elsewhere, but where no one knows the instruction. Now, this is from a note that was sent right before the end of day yesterday. So right before the end of day yesterday, they wanted to know if I have narcotics and somebody asked me for something, like say I got pills, right? And then someone says, hey, can I get a pill? And I give them a pill. They wanted to know, is that considered distribution? So at the start of court today, the judge was responding to the last note that they had gave the day prior in regards to distribution and whether or not, if you have narcotics and someone asks you for a narcotic and you give it to them, is that distribution? So this is his response to that. So it says the defense proposal is, non-responsive. And it says, as to the government on line 7, it says, as to the government's suggestion to simply answer the question, yes, the court does not believe that this would be appropriate, and this approach was not adopted by the court in Cummings when a smaller situation arose. As for the government's alternative suggestion, based on United States v. Wallace, 532, whatever, the issue there was whether a sale was required for distribution, and the court held that it was not. All right. So it is important to know the law, okay? Because if you simply have a narcotic and you don't sell it, but you give it to somebody, that is still considered distribution, all right? So a lot of people thought that distribution only meant that you sold somebody something, but the court is letting you know you ain't got to sell a thing. All you have to do to constitute it as being distribution is give it to somebody. All right. So they go on to say, but Wallace's holding is already reflected in the lines referenced in the court proposal, to the extent that the government seeks to leverage Wallace's reference to sharing. Let me change the page for y'all. It says, that wasn't really the issue in Wallace, and it's not responsive to the question asked by the jury anyway. And as Wallace itself recognized that there are prior cases like United States v. whatever, that the court and parties would have potentially addressed if a supplemental instruction based on Wallace was provided. For the reasons, the court will respond as initially indicated. We have a copy of the letter that we will send back to the jury. The court's law clerk will provide that to each side for them to quickly review, and then we'll get the response back to the jury. All right. So then Diddy's lawyer, he said, Your Honor, may I be heard? I want to supplement. We haven't had a chance to actually be heard. I know Your Honor sent us an email. The judge says you have had a chance to be heard. There was an email received by the court last evening at 6:30 p.m. Diddy's lawyer says, but I'm afraid that the court, and I say this most respectfully, is about to make something that amounts to a mistake. And let me tell the court why. First, I believe we're doing something that Your Honor has told the jury not to do. On page 1 of the court's instruction, Your Honor told them you should not single out any instruction as alone stating the law, but you should consider my instruction as a whole when you retire to deliberate in the jury room. It goes on to say, I believe we're not following some part of the court's instruction. Second, if we look on page 36, that's where Your Honor told the jury the elements of distribution. So I don't see how Your Honor could answer a question about distribution where on page 36, Your Honor says, starting at line 17, the elements of distribution or possessing with intent to distribute are as follows. And then Your Honor gives 3 elements. So Your Honor has given this jury 3 elements for distributing, for possessing, that Your Honor's now indicated you're not going to read to the jury. The judge responds and said, because that's not the question that the jury asked. Have you looked at the question that the jury asked? Child, the judge said, listen, the jury didn't ask me all that. I'm going off of what the jury asked. Sir, are you following? The judge basically said, are you following what's going on here? Where you at? Knock, knock, wake up. Hello? We on to something else. We on to something else, okay? And then Diddy's lawyer says, I have studied the question that the jury asked. And the judge says, look, you see the copy of the note. And the Diddy's lawyer says, I've memorized it. The judge says, the court's law clerk provided you with a copy of the note. And then Diddy's lawyer says, I will pull it up. The judge says, you don't need to pull it up because we have a paper copy for you to look at. Diddy's lawyer then goes on to say, I have it. And I have it in front of me. And then the judge says, okay, and Diddy's lawyer says, oh, you want me to, oh, now I get it. And then the judge says, you have what I've just indicated and you have my proposal. Now, based on what you said, you want to make sure that the jury is not somehow confused. And I don't think there's any basis for confusion to think that's the only part of the instruction that they should consider when looking at the distribution offense. That's what you're saying, all right? Well, that could be easily resolved by simply adding in one sentence at the beginning that says that the jury should consider the charge. Hold on one second. Hello? Oh, I'm on live. I thought it was emergency or something. Okay. Bye-bye. Sorry, y'all. Mommy duties. Anyways, all right. So, all right. So he says, well, that could be easily resolved by simply adding in one sentence at the beginning that says that the jury should consider the charge as a whole. And for this offense, it's reflected on these pages. In particular, the court refers to these lines and it provides those lines. That's a simple fix. If you want to do something along those lines, I don't have an objection to doing that. However, I have an obligation to directly answer the jury's question and be consistent with Cummings to provide them with a direct answer to a direct question that the jury asks, because I am not permitted and it would be improper for me to leave the jury at sea when they have asked a direct question. So I'm willing to add in the sentence that makes clear that the jury should consider the charge as a whole, which is what you've referenced to. They go on to say, however, for the reasons that I've just explained in detail, I do need to refer them to the particular parts of the instruction consistent with Cummings, consistent with the Second Circuit, has said to make sure that they understand what they need to do here. Thank you, Leela. She says, so proud of you and how far you came. Check your, my Cash App. Thank you. All right. So it says, Diddy's lawyer says, and then the court says, can you do that? The judge was not here for any of it. He said, what are we doing? Diddy's lawyer says, I don't think it goes far enough. And the judge says, it doesn't matter if you think it goes far enough. Can you do what I'm asking you to do, or do you not want to? He said, listen, I gave you instructions on how this was going to go. Can you do it or not? Diddy's lawyer says, no. I'm trying to work with Your Honor. I'm trying to throw up roadblocks. And the judge says, then answer my question. Can you do what I'm asking, or no, you can't do what I'm asking? And then Diddy's lawyer says, of course I can. Of course, do what Your Honor's asking, but I don't. Can I give Your Honor an example? The judge says, no. Can you do what I'm asking? Because I've just listened to you and I've heard what you said, and you said you're concerned. And I don't think that that concern has any basis, that somehow the jury's going to think that that's the only part of the instruction to consider in general terms. The jury's not going to think that. The jury asks a very, very specific question, a very precise question. I've reread it again just 2 minutes ago. He says, very specifically referring to this page in the instructions and referring to a question that the jury had. And so if I don't provide them any kind of guidance on how to answer that question without even referring them to a particular part of the instruction, that would be potentially confusing. That would be potentially misleading, because it might suggest to them that they should look elsewhere for the relevant instruction without any guidance on how to find it. However, I don't think it does any damage to remind them in the way that they reminded them previously, that of course they should always consider the instruction as a whole and not single out any particular part. But I do want to refer them to those lines. That's why I'm asking you, do you want to put in an extra sentence along those lines? I'm happy to consider it. All right. And then the government says, Your Honor, may I be heard on that point? The judge says, yes. I don't know if Mr. Agnifilo is done. Thank you, Your Honor. And then it says, my concern with referring to the instruction as a whole is that this is a question about a single element. This is not a question about the charge as a whole. This is not a question about whether the hypothetical in the note, the individual would be guilty of violating 21 U.S.C. 841. It is a question about the element of distribution. So this is what the government is chiming in to say. And it says, my concern about referring to the charge as a whole would be that it would be misleading and confusing for the same reasons Your Honor just articulated. They're asking about the element of distribution. The charge as a whole includes charges for 2 other crimes separate from distribution. It includes possession with intent to distribute and conspiracy, which are not responsive. And I'm concerned that a general reference back to the whole charge would get us back to the level of confusion and being misleading that Your Honor was concerned about in the first place. So for perhaps couching it and saying, with respect to element of distribution, you should refer to these lines, because that would make clear that the court's response is combined just to that element. But my concern about referring to the instruction as a whole is that that would invite the same confusion and be misleading in the same way that Your Honor was concerned the defense proposal would be. So the judge responds to the prosecution and says, I agree with Ms. Comey here. We need to get an answer back to the jury. So I'm happy to sit here. If you have a proposal for me that's consistent with and respects what Ms. Comey just said and what I've said, then I'm happy to consider it. But I do think we need to isolate the element for the reasons Ms. Comey said. If you want to further say in general terms, or you should always consider the charge as a whole, if you want to put in language on that to address your concern, I'm happy to take a look at that. And Ms. Comey will take a look at it as well. Now, Ms. Comey is the prosecutor, or one of the prosecutors out of the 6. It says, or Diddy's lawyer says, we will do that. The judge says, all right, let's take a couple minutes. I'll sit right here. I'll wait and we can get a response back to the jury. Diddy's lawyer says, and we're not waiving our objection. The judge says, understood. While we're waiting for the defense to put in their proposal, Ms. Comey, can I ask you to have someone on your team make sure, consistent with what I've previously ordered, to make sure, to the extent there are emails that have been filed, they were not reflected on the docket, to just collect those and make sure they're reflected on the docket. The government says, yes, Your Honor, we'll do that. Ms. Garagos, who I believe is on Diddy's team, says, Your Honor, we have applied for proposed redactions. I think there's only one email on our side that has not been filed and a few letters. We've sent those to the government. They should be reviewing those today, and they should be on the docket while we work. Ms. Comey says, Your Honor, I have the defense proposal, which I'll hand up. I'll note we object to it. The judge says, all right, I have the defense proposal. For the reasons I previously stated and for the reasons stated by the government, I reject the defense's proposal. So the defense wanted them to say whatever they were sending back to the jury in a particular way. And the judge said, okay, give me your proposal. All right, thank you. Rejected. They weren't trying to hear that. So they rejected their proposal and they went on to give the instruction for distribution as they saw fit. He took note from the government and then he went on about his day. So it says, you've made your objection. It's on the record, but I believe that this proposed revision would confuse the jury as to the very specific question that was asked. And so we'll provide the note with the response to the jury and we'll proceed and see if we have any other further questions. Mr. Driscoll, Your Honor, could we just put one thing on the record? Because we believe the rules about joint and constructive possession actually are relevant for the jury's question here. And I would just direct the court to the United States v. Wallace decision. It states, since sole possession in such a case would rest with the defendant, his transfer would violate the prohibition on drug distribution. And there, the issue was whether the defendant had sole possession. So, I mean, directing the jury just to this definition or distribution would mislead them. And the judge says, in what way? This was the language that was agreed upon by the parties. This language was not objected to by other side. This was unobjected to language. Hold on. This was the unobjected to language pertaining to this issue that the parties agreed would be provided to the jury. All we're doing is referring the jury to that part of the instruction. Is there another part of this instruction, of the jury instructions provided, that I read here for 3 hours yesterday that pertains to the specific issue that the jury asked about? If so, which line? Mr. Driscoll, yes, Your Honor, there is a different portion of the instruction because which line? 1 second, Your Honor. On page 38, lines 3 through 7. Then the government says, Your Honor, those lines relate only to possession with intent to distribute. This is an attempt to mislead the jury. Your Honor's proposed instruction is not erroneous in any way. It is legally correct, and this is an attempt to mislead the jury, Your Honor. Mr. Driscoll, who is one of Diddy's lawyers, but Your Honor, the rules for distribution, the judge says, hold on, you said page 38? He said, yes, lines 3 through 7. The judge says, all right, as the government notes, this has to do with the separate issue of possession, and it relates to the possession with intent to distribute. Again, the jury has given us very clear guidance as to the question that they have. They've referred to the page number. They've referred to the specific element that they had a question about. And we are referring to an agreed upon language referring to that particular element. Referencing this language or referencing the entirety of the rug distribution instructions would be misleading. All right. So the judge was on thin ice, or they was on thin ice with the judge. He said, you've put it on the record and you've made your objection. We'll proceed as the court has indicated. Anything further from the government? And the government says, no, Your Honor. Anything from the defense? The defense says, Judge, could you just mark our handwritten proposal as a court exhibit? And the court says, yes, we will make it a court exhibit. Anything further, Mr. Agnifilo? No, thank you, Judge. And then he said, all right, very good. We're adjourned. So they bring in it says, please be seated. All right. I know the parties are working on a proposed response, but just for the record, we received a note from the jury at 10:15 a.m. today that reads, all right, so hold on. Let me make sure y'all see all right. So basically, the judge ended up giving the instruction that he said that he was going to give them about distribution, and then they went back to deliberate. So while they went back to deliberate, they then came back with another question at 10 a.m. So this is what that is. So it says, we received a note from the jury at 10:15 a.m. today that reads, we would like to review the following elements of testimony/transcript. Number one, we want to get the Cassandra Ventura testimony regarding the Intercontinental Hotel incident. Number two, we want Cassandra Ventura's testimony regarding cans and the events immediately following. Number three, we want Cassandra Ventura's testimony, if any, regarding interactions, freak-offs with Daniel Phillip. And number four, we want Daniel Phillip's testimony regarding Essex Hotel with Cassandra Ventura. All right. So those are the four things. And let me take a screenshot of this that the jury wanted. All right. And again, for those of you guys who are not aware of what the testimony was, he testified that he overheard them trying to set up a freak off. He was there to shaboing Cassie. He said they went off to another room. He heard slapping and all that. And then Diddy made her get back in the room to finish off the situation. And Daniel says his wanker would not, rise to the occasion. So that's what they wanted. They also wanted the situation in Cannes where he supposedly beat her down in Cannes. And they wanted the Intercontinental stuff as well, where he beat her down there. All right. So Cassie. And what did I tell y'all? Child, it's real in the field when it comes to the Cassie stuff. All right. So the judge goes on to say, I'll start with the government. Have the parties had a chance to confer as to the transcript or testimony to provide to the jury? The prosecution says, yes, Your Honor. We are mid-conferral. We have reached agreement with respect to Mr. Phillips' proposed testimony, and we are printing out copies of redacted excerpts of his testimony as we speak. And then he says, I believe we have reached an agreement as to one of the three sections of Miss Ventura's, and with respect to another one, I believe it's the cans incident. We've reached agreement with respect to everything except for 2 lines. All right. So early on in deliberation at 10 in the morning, they already were kind of solid on what they felt as it pertained to Cassie. Okay. They deliberated shortly yesterday, and then by 10 a.m. the next day, the jury is letting the judge know, listen, well, we already kind of got our feels about, what we feel about Cassie, but we're just trying to, shuffle to, a couple of things real quick. All right. So, it says, so we've reached an agreement with respect to everything except for 2 lines. The government believes there are 2 lines that should be included. No. This is the government talking. Never mind. The government had reached the 2 lines. My bad, Charles. It's late. Redact that last part. The government is saying, I thought this was still them reading the jury note. My bad. Hold on, wait. It says, all right, let me read this again. We are mid-conferral. We have reached agreement with respect to Mr. Phillip proposed testimony. We are printing out copies of redacted excerpts of his testimony as we speak. All right, this was the government. Sorry, y'all. Child, disregard the last 2 minutes of me chatting. Okay. Anyways, let's move on. All right. So the government says, I believe we have reached an agreement as to the 3 sections of Miss Ventura's. And then with respect to another one, I believe it's the cans incident. We've reached agreement with respect to everything except for 2 lines. The government believes there are 2 lines that should be included. The defense believes they should not be included, and the Intercontinental is quite sprawling. So we are working on finding all the references to the Intercontinental incident throughout all of Ms. Ventura's testimony. So I think right now that would be helpful is to tee up for your honor the one small dispute with respect to cans. And then the judge says, very good. The government says, and I'll defer to Ms. Johnson to tee that up for your honor. Oh, I'm sorry. Ms. Johnson may not be the right person. The judge says, before we address that, just a procedural question. Does either side want me to bring the jury out to read them the note and then tell them what we are planning to send back, or that we are planning to send materials back? To date, neither side has had an issue with responding to the jurors in written form. However, if either side wants me to, I'm happy to bring the jury out to read the note into the record and then tell them what we are going to do. So as to this note, just let me ask the government, do you have a desire to have the jury brought out for that purpose? And the government says, no, Your Honor, we have no objection to that if the defense would like it, but we don't see a need. I am tired, y'all. But I'm getting through it for y'all, because if I don't read it right now, child, it is not going to get read. Okay. So anyways, so the judge said, he asked Mr. Agnifilo if he had anything that he wanted to say. He said, I've conferred with Mr. Combs and the rest of my team. We don't need to bring the jury out. The judge says, all right. And then, is that also, we've had 2 prior notes. I just want to confirm that neither side would want me to bring the jury out to read them the notes and read them the court's responses. And the government says, correct, Your Honor, our position is the same. And then Mr. Agnifilo says, ours is the same. And then the judge says, all right, as to any further note, if either side wishes that I bring the jury out to read them the note and the response after we've discussed it here, I'm happy to do so. With that, Ms. Comey, you were going to defer to a member of your team, Ms. Johnson. Yes, Judge. On point 2, The jury requested testimony on the events at Cannes and, quote, the events immediately following. The parties are in agreement as to 3 of the 4 sections of transcript to provide the jury. Our disagreement is just in the last section, which is in redirect. I don't know if the court has the capability of pulling up transcripts, but it's page 1315, or I don't know if paralegals could do that. The judge says, I think I can, but if you have it, 1350. Ms. Johnson says 1315, 1315. And the judge says, I have all the transcript excerpts except for that particular one. I'm sure I could find it in 1 minute, but if you have it, she says, I think we're working on it. It's 1315. Sorry. The judge says, what's the date of the testimony? It's on the screen now. Can the court see it? And then the court says, go ahead. Ms. Johnson says, the dispute is over line 21 and 22. The jury note asks for Cannes and the events immediately following. It's the government's position that the question, what happened when Sean was angry, and the answer on line 21 through 22 is a follow-up to Ms. Ventura's response in the previous lines. It relates to the freak-off that occurred immediately upon landing in New York, and the government thinks that should be included in the portion of the transcript that goes to the jury. The judge says, and this is the end of the discussion. Ms. Johnson says, yes. The judge says, I said Cannes, but apparently I'm wrong. Ms. Johnson says, it's our position that this is the end of the discussion, and the line 23 moves to a new topic or discussion. All right. So then it says, I'll let Ms. Garrigo speak, but I understand the position of the defense is that this is a more general response that shouldn't be included, but it's our position that this is a follow-up to the discussion of a freak-off that happened and the events leading to that point. The judge says, I'm looking at this and I would likely cut the testimony off at line 20. So if the dispute is about line 21 and 22, I would exclude that from what goes back to the jury, but I'll hear from Ms. Garrigos. I have nothing to add, Your Honor. And then the judge says, and any other disputes or issues to address in terms of what goes back to the jury? Ms. Johnson says, not on this issue. I imagine we would need to speak to the court about the Intercontinental, but we would like a few more minutes to work through the transcript. The judge says, please let the deputy know when we're at a point when we can resolve that, and I'll come back. And it says, thank you very much. All right. So let's go to the next one. It says, please be seated. I understand that there is the issue to resolve. Mr. Donaldson, which is Diddy's lawyer, says yes. The court, what's the issue? The government says, I understand that during the break, the defense came up with an issue regarding Daniel Phillip. So I'll let the defense raise that because that's their issue. The judge says, is there also an issue concerning the time frame, or have the parties resolved that issue? Ms. Johnson, we still have that issue as well. And then the judge says, all right, so let's address the Daniel Phillip issue first. The real VLC says, maybe you should try reading it with some characters so it won't be so boring for you. The real VLC, girl, it is 12 a.m. on a day where I was at the courthouse for hours and hours and hours, came back and been up working on other things. It is 12 a.m., child. If it's boring for you, because I'm just reading it, if it's boring for you, there's nothing I can do to help you out because I don't have any character to give you at 12 a.m. after a full day at the courthouse. I just don't. So, hey, you know, if it's boring for you, pause and read, okay? That's the only suggestion that I can give you. But anyways, All right. So Diddy's lawyer says, he says, yes, Judge. We have looked at question number 4, which says Daniel Phillip testimony regarding SX Hotel incident with Cassie Ventura. We are in agreement with everything except for pages 283, line 11 through 16. The government believes that question and answer should come in, or the government believes that's responsive. We believe that it's not. The court says, can you give me the transcript page? Diddy's lawyer says, page 283, line 11 through line 16. That includes the question and answer. We are suggesting that does not, or it's not responsive as it relates to post thought process by Mr. Phillip related to the incident, not regarding the actual incident. So that's our position. All right. So let's go on to the next page. All right. So it says the government's position to the question is asking what he thought about or why he didn't do something after the incident does respond to the question, which is asking to tell them about what happened during the incident. The government says, Your Honor, our position is the request is for Daniel Phillip testimony regarding SX Hotel incident with Cassie. The question and answer are regarding the hotel incident with Cassie. I don't see a problem with providing this testimony, which is regarding that topic and which was admitted at trial. The judge says, all right, and we're not going to include lines 16 through 18. And then the government says, Your Honor, correct, Your Honor. We've redacted those with your honor struck from the record. And then the judge says, all right, so the testimony at issue pertains to the incident that's being discussed in the preceding passages. She says, exactly, Your Honor. The judge says, all right, so that testimony will be included. And then Ms. Johnson says, point 1, that the jury requested is testimony of Cassie Ventura regarding the Intercontinental Hotel. It's the government's position that the incident is what occurred at the hotel the evening of March 4th into the day of March 5th. So right now, if you guys are not following along, they are basically arguing about what they want to give to the jury. Okay. So the jury requested 4 or 5 things that they wanted back. They wanted Cassie's testimony for the Intercontinental incident. They wanted Daniel Phillip's testimony. They wanted about the cans incident, and they wanted several testimonies. So right now, they're pretty much fighting for which portion they're sending back to the jury. Okay, so these are the lawyers battling it out about, okay, well, include this line, don't include this line, include this part, don't include that part. So that's kind of what they're going back and forth discussing right now, if you guys have not followed it. All right, so let's continue. So it says there's testimony in the record about events starting several days before and text messages starting several days before and text messages that go after the incident. So we're looking for some guidance from the court. It's our position that it should be the incident at the hotel. That's what we're looking for. In addition, the defense also proposed including Ms. Ventura's testimony about her IG post from 2024. After the video was publicly released, which we think is not responsive to the jury's request, and they also marked her testimony about her settlement with the Intercontinental Hotel, which we also think is not responsive to the jury's request. The judge says, all right, let me hear from Ms. Garagos. Ms. Garagos says, thank you. We have proposed parts of the testimony. Ms. Johnson says several days before, but there's a government exhibit with Your Honor recalls is the I want to freak off so bad from Ms. Ventura. On our cross from completeness reasons, we introduced 1088. I think the defense exhibit number was, and it's just the beginning of the conversation. It's Ms. Ventura reaching out to Mr. Combs while he's sick, and we believe that is essential to the entire intercontinental incident because it's hard to kind of parse the testimony as to when the planning of the alleged freak-off started without having the testimony related to both of those exhibits. All right. It says, which is why we included testimony starting from the defense exhibit 1088 messages. And so we have proposed that the testimony regarding those messages be included in the response to the jury note. Question number 1. We did not include any of the testimony regarding Miss Ventura when after she left the Intercontinental. Her testimony about going to her home, Mr. Combs going to her home, Miss Karam and D-Rock, etc., because we don't believe that that's directly responsive to question number 1 regarding the hotel incident, because it is at that point that she leaves. But we did include then testimony regarding several messages from after the Intercontinental incident when they're talking about the Intercontinental incident and her and Mr. Combs. So because the question is specific to the testimony regarding Intercontinental Hotel incident, we did include testimony from several days afterwards because between where she's talking about conversations between herself and Mr. Combs because it's regarding that incident. So that is the reason for our proposal. That's some testimony regarding about a day and a half prior, because we believe that's when the planning of the freak off starts and is essential to the jurors' understanding of whether Mr. Combs coerced Ms. Ventura into the commercial S on that date. And then we did include some testimony It's limited, but between that, Ms. Ventura testified about her conversations with Mr. Combs several days after. We believe that is also relevant to whether Mr. Combs coerced her on that date to engage in a commercial S act. All right. If you guys are enjoying hearing every single detail that happened in the courtroom today, definitely hit that like button, and shout out to everybody who saw me on CNN. All right, shout out to y'all for checking it out. It says, and then there are 2 disputes regarding the settlement, which has to do with the Intercontinental incident and the Instagram post, which also has to do with the Intercontinental incident. So that's the reason for our proposal. The judge says, focusing on that last 2 issues, can you just remind me of how does the post regard? The request was for Ms. Ventura's testimony regarding Intercontinental Hotel incident. So how does the 2024 post regard that incident in a more direct way than, for example, the aftermath of the incident itself when Ms. Ventura went home and Mr. Combs went to her house? All of that testimony? Ms. Garrigo says, I think because the exact question posed to Ms. Ventura was, you recall posting on IG after the video of the Intercontinental Hotel was aired in May of 2024. So it's a direct response to the video of the incident at the time. We are including in our proposals her testimony regarding watching the video in court. And so we think it just completes that testimony. It's all of her testimony regarding reactions to the video. All right. So again, this is the lawyers basically battling it out on what they feel is relevant parts of the testimony that Cassie testified to, that they're requesting to read back in the jury room. All right. So there's that. Let me make sure we both got the same pages up. All right, and hit the like button if you haven't already. All right, where was I at? The judge says, so the settlement is you'd agree a few steps removed, meaning it's just the fact that of the settlement. And then Ms. Garrigo says, we're withdrawing the settlement, Your Honor. And then the judge says, all right. As to the other, I'll hear from Ms. Johnson. Ms. Johnson says, Your Honor, starting with her comments on Instagram in May of 2024, it's not all clear to me from the testimony. It just says, you recall posting on IG after the video was aired, and is discussing snippets of what she posted on Instagram after this video became public in May of 2024. The focus, of course, is that she wrote, among other things, in her post that DV is the issue. I don't think this has any relevance to what the jury is asking about. And if the argument from counsel is that putting in wide swaths of testimony is important to assessing Ms. Ventura's coercion, the government would submit that the 2 lines excluded from the comments are critical in assessing coercion. And in addition, the lines that the defense excluded from what happened after the Intercontinental incident is also critical. The judge says, Ms. Garagos, what is the actual questions and answers that you want to put in regarding to the 2024 post? Do you have a page number? Ms. Garagos says, yes, it's on transcript page 1294. The judge says, all right, so can you show me the testimony as to the events preceding and the events post-dating the incident that you would also want to put in? Ms. Garrigo says, sure. I think I'll start at our first dispute. I think that makes sense, but that's post-dating. We suggest we all agree to start at transcript page 629, line 15. The first dispute begins at transcript page 639, line 16, and we believe it should end there. The government, I believe, thinks that it should go on for about 10 pages, so perhaps we could start there. I don't know if Ms. Becker could pull up the next page or Mr. Gavin, and then it says, thank you. So again, they're pretty much going over what they should introduce as it pertains to Cassie. Let me try to skip ahead a little bit to when they get some resolution. Let me see. So let's skip ahead some. All right, so they're basically debating whether they're going to send in her IG post or not. So let's move to page, let's see. All right, let's go to line 22. The court and Ms. Garrigo, the judge says, Ms. Garrigos, in fairness, for the reasons that you've articulated as to why the post-event messages regarding the incident would be relevant, then the same category will also be applicable to what the government wants to put in. If there are communications or testimony about communications that regard the incident or injuries that Ms. Ventura sustained during the incident, those will fall into the same category. I'm not hearing from Ms. Johnson that she is pressing on testimony concerning the aftermath or what happened afterwards, right, Ms. Johnson? You previously were. And then she says, no, I still am. The message from March 5th. All right. So the judge says, put that aside. So let's go down some more. And let me turn down the air in my room because it is kind of cold. Hold on. The air is blowing cold. 1 second, y'all. I ain't trying to freeze up in this thing. That air start blowing right on the kid. Like, hold on. Where y'all at? Are y'all in the chat? Did y'all fall asleep? Should I go to sleep? I mean, what's it giving? I'm like, if y'all going to sleep, let me go to sleep. Let me know what's happening. No, no, I'm just kidding. I just want to see y'all in the chat. What's it giving? All right, let's move ahead. All right, so again, they were basically going over what they should give to the jury or not as it pertains to Cassie's the Cassie transcript request. All right, so let me figure out when they move along because they kept belaboring all of this stuff. Let's see. All right. All right, so they're just going over what they're sending back. All right, so let me see what page where we get some type of resolution. Oh, okay. All right. Dang, we already to the verdict. Hold on. Okay, let me go back. Let's see. All right, okay, we're almost to the verdict, y'all. Somebody said, Neat, go to bed. Child, we almost to the verdict part. We just got a couple more pages and then it goes to the verdict because they just only do the transcripts in between the notes. All right, so let me see. What page is this? Let's move forward. All right, so Miss Garrigo says, we agreed the testimony regarding a few, I'll say 2 days before March 3rd, 2016, which is the testimony that we proposed, begins on 1091, lines 11 to All right, so it says, Ms. John, let's go to the next page. You know what? Let's go to the verdict, child. All right, so they were adjourned. They figured out what they was gonna give for Cassie, child. Let's go to the next thing. Let's skip ahead, y'all. We gotta skip ahead. All right, so at 4 o'clock today yesterday rather, is when the verdict came in. All right, so this is when it was intense in the courtroom. This is when it was like you can hear a pin drop and you can just feel the tension rising as you saw his lawyers pacing around him and trying to figure out what this means so early in the game. All right, so let's read through the transcripts and let me see what time. Okay, we are at an hour. All right, so the judge says, please be seated. All right, we've received the note at 4:05 p.m. today. The note reads, we have reached a verdict on counts 2, 3, 4, and 5. We are unable to reach a verdict on count 1 as we have jurors with unpersuadable opinions on both sides. So what that means is there is a side of people who feel he is absolutely guilty of racketeering. And then there are sides of the jury that feel he is absolutely not guilty. And both sides are saying we cannot be persuaded on this. Okay. I think he's guilty. I think he's not guilty. And they are sitting in their corners, not budging. All right. So that's pretty much what that is saying right there. Now, it goes on to say, we'll make this letter a court exhibit. It was previously furnished to the parties, so I'll inquire with the parties if they have any proposal as to a response or approach to address the juror's question. We'll start with the government. Ms. Comey says, Your Honor, we're putting together a proposed modified Allen charge that we ask for Your Honor to give to the jury to encourage them to continue deliberating as to count 1. We think that the jury has not been deliberating for nearly enough time for them to give up at this juncture. And we think a modified Allen, not a full Allen charge, but a modified Allen charge will be appropriate. And we're putting together language to propose for Your Honor. The judge says, all right. So then Diddy's lawyer says, yes, Your Honor. Thank you. It's our request that you, the court, tell the jury to keep deliberating. We do not take a partial verdict. The jury's only been deliberating for a day and change. I don't believe that we are at the point of a modified Allen charge. He goes on to say, I think our proposal would be that the court tell the jury that the courts received the jury's notes, noting that the jury has not yet reached a verdict on count 1, and that the court advised the jury to continue deliberating without any kind of modified Allen charge at this stage. The judge says, all right, and would the defense request that I bring the jury out to provide that instruction? Nifilo says, 1 second, Your Honor. Yes, we would ask that Your Honor bring them out. The judge says, all right. Can you write down or send an email with the proposed instruction, and I'll ask the government to do the same on your proposal? Ms. Comey says, yes, Your Honor. The judge says, all right, so I'll wait here and you can email the proposal to the chamber's inbox and we'll take it from there. The only thing that I'll raise is that there are essentially 3 options here. One would be the defense proposal to essentially tell the jury, in light of the fact that they've only been deliberating for a day or so and change, that they should keep at it, which is the defense's proposal. The second proposal would be some version of an Allen charge. It says, you indicate a modified Allen charge. I take it that it would be a softer version of the Allen charge. The government says, exactly, Your Honor. And the judge says, and the third option is at some point, there is case law indicating that the court should advise the jury of its ability to return a partial verdict under Rule 31. I'm not sure that we're at that stage, and I don't see either side suggesting that we should give that instruction to the jury. So those are the options. All right. So I'm going to read that part again for y'all. All right. Because there was a dispute whether the judge could exercise the ability to go forward with the charges and read them and put them into effect, counts 2 through 5. And this is what he said. Let's read it again. He said, at some point, there is case law indicating that the court should advise the jury of its ability to return a partial verdict under Rule 31. Now, that is stating, it is possible for them to go and do a partial verdict. That is a possibility. The judge is saying, I think it's a little too soon for us to say that we're going to do that, but he said that it is possible. Okay. People were saying, oh, no, it's not possible. They can't reach a verdict on count 2 through 5. And then unless they have the RICO. That's not what the judge said. Okay. I was in the courtroom. I was listening to the judge when he said that. And he said, it's possible under Rule 31. I just don't think that we're there yet, but it is possible. All right. So to the people who are wondering, is it possible that he can be found on the findings of the jury for count 2 through 5? Yes. The only thing is they just want to make sure that the jury has deliberated long enough for that to be the issue that they're going to go with. They're hoping that, listen, they sleep on it, they think about it, and whoever was wavering from one side to the next goes and, has a unanimous decision one way or another on that charge so that he doesn't have to do that. But it's possible. All right. So it's definitely possible. And it's on line 6 of page 39 of the transcripts. All right. So he says, and I don't see either side's suggestion that we should give that instruction to the jury. So those are the options. I take it that the parties have staked out the first two, and I'll take a look at the proposals, and then we'll decide how to proceed at that point. And he says, all right, I've received both sides' proposals. Mr. Agnifilo, if I were to provide the defense's instruction to the jury, it's not much. There's not much there. And Mr. Agnifilo says, there's not much there because this is a jury that by their note has reached verdicts on 4 counts. And I don't know what the jury really needs help moving efficiently through the material. It was a long trial. There was a lot of evidence. They've been deliberating, I don't know, maybe 12 and a half hours, 13. And in that time, the note indicates to us that they've reached verdicts on 4 counts. So I don't know that we're remotely at the point where this jury needs anything extra in order to deliberate efficiently. This is a remarkably efficient jury. They're moving through the materials, they're making decisions, and they're unable by virtue of their note to reach a decision on one of the 5 counts. And so I recognize, and your honor's right, I'm not asking the court to say much, and that's because I don't think that this jury needs much. And I don't think that this is akin to other situations where in shorter trials, juries have been deliberating for longer or as long and haven't reached any verdict. I think the dispositive difference is this jury has already reached 4 verdicts. So I don't think that we need to do anything to move them along. They've been moving along fine. The judge says, how do you address the note which indicates that as to count 1, we have jurors with unpersuadable opinions on both sides? So if we were to respond to say, keep deliberating without any sort of reminder as to what that means, then we would be non-responsive to the jurors' questions. Part of the government's response, I wouldn't really call the government's proposal an Allen charge. I think that what it principally does is to remind the jury of instructions that I previously gave as to what the deliberation emails, meaning that most of what the government has proposed is just repeating of the section of instructions on the duty to deliberate, and that's consistent with the defense proposal so well. It says, so what we could do is to use your personal, and after I ask them to keep deliberating, I could simply recite for the jury, if you're looking at the jury charge from on page 58 through 59, 58 line 11 through 59 line 2, omitting 58 lines 17 and 18, which would not be applicable here. And that's more or less what's reflected in the government's proposal, and it would not be adding new material. It simply refers to the jury to the section that I already gave them on the duty to deliberate. All right, so then Diddy's lawyer says, so the proposal is 58 line 11 to 59 line 2, and your honor would not read line 17 and 18. He says, right. So 58 line 11 through 16, 58 line 19 through 59. Mr. Agnifilo says, I think that makes a lot of sense, Judge. The judge says, all right. He goes and talks to the prosecution. He says, Ms. Comey, do you have any objection to that? Ms. Comey responds and says, I have no objection to it, Your Honor. The one additional sentence that I think might be helpful, given that the jurors have clearly been looking at the instructions and have been diligent, would be the sentence in Avenatti case that we proposed, which says there's no reason to believe that if this case were to be tried again, that another jury would be any more intelligent or more impartial or more competent to decide than you are. All right. So then they go on to say, it gives a little extra to inform them essentially that this case would have to be tried again. And if they could not reach a verdict, and it might help them take a harder look at the instructions, which is, I think we need the right now is for them to take a harder look at the instructions and continue deliberating. So that one sentence that they have something new would be my proposal. And again, it comes from the language that the circuit blessed in Avenatti. Mr. Agnifilo says, and this is Diddy's lawyer, I think that goes way too far for the jury that reached verdicts on 4 counts. I note Your Honor's proposal. It wasn't our choice, but when Your Honor said it, it made sense to us. I don't think that they need new language. I don't think they certainly need to be told what the proposed modified Allen charge was that the government recited. This is a jury that has been efficient. They're productive. They've reached verdicts on 4 counts, and I think that they're very well aware of the gravity of the situation. And I don't think that I'm not saying we wouldn't be at that point Thursday or Monday, but we're not at that point yet. And so I like Your Honor's proposal of what Your Honor read combined with our proposal. The judge says, all right, and to be very clear, Ms. Comey's proposal and something even more definite may be warranted depending on what happens. It says, meaning this happens in stages. So what we say to the jury now is without exclusion to what we may say to the jury the next time they come back with a note. Mr. Agnifilo, Diddy's lawyer, says, that's always the case, but we wait to see what the jury comes back to us with. Again, I'm putting a lot of stock in the fact that this jury in a long trial has reached verdicts on 4 counts. The judge says, all right, so I'm going to provide the instruction as proposed by the defense with the modification that I made without prejudice to something more in line with the government has requested. If there's any further notes that we receive from the jury, while we're here and discussing these things on the assumption that the jury is going to want to go home at this point or sometime soon, the issue is raised as to what happens on Thursday because the court is closed on Thursday. And so there are 2 options. The one option would be for me to inform the jury that their deliberations persist through the day tomorrow, and then they would come back on Monday, July 7th. I can also tell them that if they all agree that we can bring them back on July 3rd, and I believe we can make accommodations for that. However, that does pose some unique logistical issues. For instance, if there is a verdict or other circumstances arise. Which way do the parties want to go, or are you agnostic as to those 2 options? Because I'd like to tell them that now so that they have that in mind. Ms. Comey says, Your Honor, our presence would be to give them the option to deliberate on the 3rd. And our preference would be to give them the option to deliberate on the 3rd. And if they all agree to deliberate on the 3rd, if necessary, that they would be permitted to do so. And then Mr. Agnifilo says, 1 second, Your Honor. He says, yes. Mr. Agnifilo says, Your Honor, we've discussed it on our side. Our preference would be that you most respectfully ask the jury at the end of the day tomorrow, and here's why. We're concerned that the jury will feel some desire to try to reach a verdict faster than may be otherwise, so that the Thursday issue would be settled one way or the other. And so our preference would be that Your Honor does not tell them now. And I understand that the court wants to tell them now because there's a courtesy to that. And I appreciate that and I recognize it. But I think the downside from our standpoint is that the jurors, some of them might feel rushed or feel some sort of pressure to render a verdict or not more quickly than otherwise. And so our preference would be to let them deliberate. And it seems like they're making progress. Let them deliberate tomorrow. And at the end of the day tomorrow, the court can ask them if they want to sit on Thursday. Now, I'm also mindful, I'm not aware of the logistical things that the court has to deal with on this front, but I'm just talking from our perspective in terms of what we think is better to keep the jurors' minds free and have them focusing on issues. The judge says, all right, but to confirm, we can at least confirm this. There's no objection to our proceeding on July 3rd. And then he said none. And then the judge says, okay, good. So we can work out whether that is logistically feasible to come back on July 3rd. And we can come back in the meantime. Diddy's lawyer says, very good. And then the judge says, your proposal, though, is to wait until later in the day tomorrow to see if we still don't have a verdict. And at that time, raise the issue with the jury. Then Mr. Agnifilo says, that is our proposal. The judge says, if the jury decides they've talked amongst themselves and decide they want to go forward, then the parties are in agreement that we can do that. Mr. Agnifilo says, on July 3rd, absolutely. The judge says, all right, then we can take care of the logistical issues. If there's a logistical hiccup, if we can't do it on the 3rd, then we'll talk to the parties in advance. Otherwise, we'll bring the jury out to provide them with instruction. And I'll tell them at the end that if they have completed their deliberations for the day, then they can go back, send us a note, and then we'll bring them out for some closing instructions. And then the jury comes in and the judge tells them to be seated. He says, welcome back, members of the jury. Thank you for all your hard work. I've received your note that you have reached verdicts on counts 2 through 5, but not on count 1. I ask at this time that you keep deliberating in doing so. I will remind you of the instructions I gave you yesterday. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement. Each of you must decide the case for himself or herself, but you should do so only after a consideration of the case with your fellow jurors, and you should not hesitate to change an opinion when convinced that it is erroneous. Discuss and weigh your respective opinions dispassionately, without regard to sympathy, without regard to prejudice or favor or either party, and follow my instructions on the law. Again, your verdict must be unanimous, but you are not bound to surrender your honest convictions concerning the effect or weight of the evidence for the mere purpose of returning a verdict or solely because of the opinion of other jurors. It says, wait, where was I at? Each of you, hold on, let me make sure y'all on the same page. I'm feeling like I'm behind. All right, it says, each of you must make your own decision about the proper outcome of this case based on your consideration of the evidence and your discussions with your fellow jurors. No juror should surrender his or her constituents' beliefs for the purpose of returning a unanimous verdict. Thank you. At this time, I'll ask you to return to the jury room. If you are done for the day with your deliberations, you may send us another note and we'll bring you back here very briefly and you'll be able to go home at that time. Again, I thank you. I thank the jury for all your hard work. So the jury leaves out the court. Everybody in the courtroom sits down. And the judge says, be seated, everyone. Can you go back to doing whatever they're doing? I'm only sitting here because we may get a note in the next few minutes. And then he says, all right, we received a note from the jury that they are completing their deliberations for the day, and we will resume tomorrow at 9 a.m. So with that, we'll bring out our jury. All right, so it says hard work. I'll give you just a reminder of the instructions I gave you yesterday, which is I won't be bringing you out in the morning tomorrow, so you'll go directly into the jury room. Do not start your deliberations until all 12 of you are there. If all 12 of you are not there, then you can talk about the sports, weather, anything else, but not anything concerning this case. Also, remember to keep an open mind as you continue your deliberations, and no communication with each other about the case in the meantime until you recommence your deliberations. No communication with anybody else about anything concerning this case, and please do not watch, read, or look up anything concerning this case in the meantime. With that, I wish you all a great evening, and we'll be seeing each tomorrow. If there's a note earlier in the day, it will be sooner than later. But I wish you a great evening, and we'll see you tomorrow. And then the jury left out. And then the judge told everybody to be seated, and he wanted to know if Diddy's lawyers had anything that they wanted to say. And they said, no, Your Honor, no, Your Honor. And then he says, all right, so we'll see everyone tomorrow. Again, if there are any issues to address before the jury starts, let us know by this evening so that we can all come back early before the jury starts. So that is the full transcript for today. And hopefully it gave you guys some insight on what was said in the courtroom. Now, again, we cannot know what was said in the jury deliberations, but a lot of people want to know, like, what did the court say and what issues were raised and what questions were asked and what was requested. And today, everything that was requested was pertaining to Cassie. All right. So everything that they wanted to know as it pertained to when she had an instance where he put the pause on her and then made her do a freak off. Now, all about Cassie, nothing about Jane. So let's take that as you will. Somebody said you read like a third grader. Well, whatever level of reading that you read at, make sure that you pause my third grade reading and you read at the level that you think is appropriate. Okay. Or perhaps, you know what you also can do is go to the content creator that reads at the level that you like them to read. It is midnight, almost 1 a.m. after a full day in court, girl. And if you want it to be read any other type of way, honey girl, you could pause it and read it in whatever advanced level that you like, honey. You know, we will not miss you, okay? We will not miss you over here, child. If you let the dough hit you where the Lord split you on your way out, okay? Or, however that saying go. But anyways, shout out to all of y'all in the chat. And so we shall see what happens tomorrow. Now, I don't know. It feels like they already were moving very swiftly in the process. So we are definitely going to see how swiftly they are going to move tomorrow. Now, somebody said, why are people so mean? Because they be wanting attention. They be wanting attention, child, because it ain't nothing to just click off the video if you feel like somebody is not performing at the level that you want them to, so they say those things to try to, get some attention while trying to, tear you down, as if they can't see it's late. But anyways, Yeah, you say it's crazy how fast they came back with a verdict. It definitely is. Definitely crazy. Before I go, let me share with y'all the CNN piece, or should I do that separate? Are they gonna flag my video for sharing it with y'all? I might do that separate. I might do that separate. We'll talk more about it tomorrow. And then maybe tomorrow from the courthouse, I'll read you guys Daniel Phillips' testimony so that you guys can see the exact testimony that they wanted to hear about. All right. I can pull up the different transcripts and pull up the different things that was testified to if you guys would like, while we're waiting for a verdict. But it is 1 a.m. Court is tomorrow at 9 a.m. They start back deliberating. So let me get a couple of good hours real quick. Okay, let me give me a couple of good hours, looking outside this view and whatnot or whatever. We love a good view. But yeah, I'm going to give me some rest. Y'all have a good night as well. And I'll see y'all later. Thank you. You said my blue dress was cute. Thank you. I was trying to look like a little something. All right. Good night, y'all.